And as decisions are released with the wind down of this year's term, we're following several cases at the U.S. Supreme Court. Appellate attorney and constitutional scholar Adam White joins us to talk about the decisions we're waiting on. Adam served on the Presidential Commission on the Supreme Court and is a senior fellow at the American Enterprise Institute. Adam, it's great to have you here with us. Let's start with one case where we already know the decision. What we dubbed the case about pork that really isn't about pork. Out of California, we had the National Pork Producers Council challenging a California regulation that asked pork producers selling within the state to treat their pigs with specific care guidelines or be refused the ability to sell their products in the state. Why should we care about this for businesses?
It was a case about pork, but it was primarily a case about interstate commerce. The Constitution gives Congress the power to regulate interstate commerce, and there's always been questions about how much power the states themselves have to interfere with interstate commerce. California, in effect, tried to reach out beyond its state borders and regulate industries outside of the state. The Supreme Court majority said that's okay because California was primarily trying to regulate sales within the state. But as the dissenters pointed out, this leaves a lot of room for states like California to try to wield disproportionate weight in the American marketplace and, in effect, try to export their policies to other states.
And how could this have some kind of implications for issues like abortion? I know that's on everyone's minds.
Well, in the aftermath of the Dobbs case, there are questions about the extent to which states might be able to limit not just abortions within the state, but also limit the ability of people to travel out of state for abortions or for companies outside of states to serve customers within the state. And so there have been questions about the extent to which states might be able to limit the flow of those services in or out of the state, the flow of people in and out of the state. Frankly, the Supreme Court's decision, I don't think said a lot implicitly to those issues, but a lot of us were watching for clues.
Any clues that we can look to?
Not yet. Right now, the fight over post-Dobbs abortion cases really does seem to be focused first and foremost, as you pointed out, not in the states, but in the administrative state, where federal agencies under the Biden administration really are trying to push forward on a pro-abortion agenda in spite of the laws that govern those agencies.
Well, let's switch to another issue, the issue of wedding vendors that continues at the Supreme Court since the creation of same-sex marriage in 2015 with the Obergefell case. A Christian wedding website designer in Colorado that sued to protect herself and others over the Colorado Anti-Discrimination Act, which would force her to violate her conscience and provide her creative services for same-sex unions. What can we expect with this case?
Well, this case reminds us how difficult it is, especially in industries around weddings, to strike the right constitutional balance between the regulation of commerce, the freedom of speech, and the freedom of religion. Here in this case, the court is primarily focused on the free speech issue, whether the state's regulations of this wedding website service violates the web designer's free speech rights, but of course it is bound up with her religious beliefs. It seemed after oral argument that the Supreme Court majority was leaning in favor of defending free speech rights in this case, but it's not clear, even if they do rule in that direction, where they'll draw lines, because over and over again, we're going to see commercial regulation that touches on free speech, especially in the context of same-sex marriage.
And anti-discrimination laws. How is this case different from the Jack the Cake Baker and other wedding vendor cases that have come up to the court?
Well, in the bakery case, there were a lot of questions, debate about whether the making of a specialty cake constituted the expression of views or religious beliefs by the baker. Here, when you're talking about web design, it is clearly speech. The question is whether it's the speech of the viewpoint of the web designer. I think it is much more, even more clearly, a free speech case than the Masterpiece Cake Shop was on free exercise of religion. And of course, there were real free exercise of religion considerations at issue.
There's a concept called public accommodations that everyone talks about when you think about these cases. Basically, if I come into your shop and you're set up in the marketplace, you have to serve me and you have to do what I ask for, whether I'm LGBTQ or a Christian asking someone who doesn't believe in Christian beliefs to work with them. What can you tell us about that? Any clarity there?
Well, this is a really hard issue. In our country, we've long prevented commercial interests, companies and others, from discriminating on the basis of race, on the basis of sex, and so on. This is another core commitment of American government, American political life. But in these cases, it is bumping up against the free speech and religious free exercise interests of the business owners. And in the Masterpiece Cake Shop, we saw, and this was the heart of the court's concerns, we saw a real effort to target the bakery, not just by the litigants in that case, but by some of the people in the Civil Rights Commission in Colorado. So that often is hovering around these cases too, the intentions of the regulators who seem to be targeting particular kinds of companies for particularly bad treatment.
Well, we'll have a conversation about regulators in a moment, but let's talk about another case argued on April 18th, just last month, and it's also pending a decision. A former part-time mail carrier and evangelical Christian sued the U.S. Postal Service for having to work on Sundays. This is the issue of protecting Sabbath observance, but also of religious accommodations by big businesses. What does the law currently say?
Well, a moment ago, I said that our civil rights laws protect customers against illegal discrimination. Another part of the Civil Rights Act also protects employees against discrimination on the basis of race and sex and also on religious belief. It's supposed to protect your ability to exercise your religion without discrimination against you by your employer. Of course, sometimes employers do need people to, say, work on the weekends and so on. So the law tries to strike a balance. You're entitled as a religious employee, you're entitled to a reasonable accommodation, but not one that imposes an undue hardship on the employer. So in this case, the Postal Service, which is being sued not because it's part of the government, but because it's an employer, the Postal Service is being challenged for not allowing this person to have off on the Sabbath. The Postal Service has a contractual relationship with Amazon for delivering packages now on the weekends. And the parties seem to agree that the existing case law is a little dissatisfactory. It probably isn't clear enough, and the case law doesn't provide enough protection for religious liberty. The question is, how much more protection will the employee get in this case? And we have yet to see.
Yeah, and we're talking about Title VII religious protections, right? Where, unfortunately, there's another fancy legal term, de minimis, these tiny, tiny accommodations that businesses have to make for our religious rights. Doesn't religious freedom deserve a little more than that?
Well, yeah, and the text of the law seems to require more than that, too. It speaks not in terms of more than de minimis burdens on the employer, but an undue hardship on the employer. And the justices and even the government, the Postal Service, seem to recognize that the existing de minimis standard probably isn't enough protection. The question is just how much more protection, and does the Postal Service's interests in this case, in terms of this particular location, this particular set of employees, this particular employee who's looking for an exemption, whether the Postal Service needs to allow this person to not work on the Sabbath.
Well, Adam, we're going to be looking to your expertise when these decisions come down. Thank you so much for being with us.
Thanks, Montse.